Hello students, welcome to Legacy AIS Academy. Today we are going to discuss about the issue of the definition of minority. That means who is a minority or who can be classified as a minority in India, and what has been the stand of judiciary on this particular issue. And we are also going to discuss about the various important cases that has been discussed in Supreme Courts and the High Courts regarding this particular matter. So let us start and try to understand about the issue. So first of all, the context that why we are discussing this particular issue is because the Supreme Court of India has decided, that is on the Monday, that is today 28th of March, it will take a petition that has been filed in the Supreme Court of India that seeks to identify the minorities at the state level. And the main reason that is for the identification of minorities at the state level is because the petition seeks for the granting of a minority status to the Hindu community in such states and union territories where the numbers or their percentage share in the population of the state has become very low as compared to the other communities. Currently, if we try to understand the method or criteria by which identifications of minority is done, so only those community that is notified under section 2C of the National Minorities Commission Act, also called as NMCA 1992, by the central government can be regarded or are regarded as a minority. So let us try to understand about the details of this particular case. The petition has been filed by an advocate and it is based on the ruling that has been given by Supreme Court in two major cases. One was the 2002 case, that is the TMA Pi Foundation case, and others versus State of Karnataka. Well, the second ruling was in the year of 2005 when the Supreme Court has given a judgment in Bal Patil and another versus Union of India and others case. So seeking these two as a basis, advocate had said that if we try to understand why they are seeking minority status for Hindu community is because they have said that as per the census of year 2011, if we try to understand about the percentage share of Hindu community in different states, so in state of Arunachal Pradesh their share is just 29%, in a state of Nagaland it is 8.75%, in a state of Meghalaya it is just 11.5%, in the state of Manipur it is 31.4%, while in the state of Mizoram it is only 2.75%. Similarly, in northern India, in the state of Jammu and Kashmir, the share of Hindu population is only 28.4%, while in the Punjab it is only 38.4%. So these are the 7-8 major states where the population or Hindu population is much lesser as compared to the population of other religion. So how the minorities has been decided and defined in the constitution. So for this, as far as the constitution is concerned, there is no such concrete definition that has been given for the minorities. However, there are certain articles that have classified the rights of minorities. The first and foremost important article is Article 29, which basically deals with the right for any minority groups, whether it is a linguistic minority, whether it is a religious minority, to a right to conserve their language, script or culture. And at the same time, the constitution under Article 29 clearly states that no citizen, whether belonging to a particular minority, linguistic minority, religious minority, ethnic minority, shall be denied admission into any educational institutions that is maintained by the state or received aid out of the state funds on the grounds only of religion, race, caste, language or any of them. So basically it prohibits any form of discrimination in the state-run or state-aided educational institutions for the minorities. The second important article is the Article 30, which basically have defined the right of minorities to establish and administer educational institutions of their choice. And here also the Constitution has clearly said that any minority educational institutions cannot be discriminated whenever the matters come in granting aids by the state or central government on the sole ground that it is under the management of a minority, whether it is a religious minority or whether it is a linguistic minority. That means the state and central government have to keep all the educational institution on the same level without discrimination, that whether it is run by minority trust or whether it is run by minority religion or minority language group, or whether it is run by majority or majority religion or language group. The next important article is Article 350A, which has made a provision for setting up an office that is for Special Officer for Linguistic Minorities. And the main reason behind setting up of this post and office is so that Special Officer for Linguistic Minorities, if time demands, can investigate all matters that is related to the safeguard of minorities, especially for linguistic minorities, and then the Special Officer for Linguistic Minorities will report to the President of India, and President, whenever the session of the Parliament is held, will present this report to the Parliament of India. So we have discussed that as of now only section 2C of the NCM Act can define minorities. That has been done by the Government of India on October 23rd, 1993, under which 5 minority groups were identified. Those were Muslims, Christians, Sikhs, Buddhists and Parsis. However, the recent changes had made in the month of January 2014, when Jain were also added as religious minorities in India. So as of now we have 6 different minority groups as per the section 2C of the National Commission on Minorities Act. Now let us try to understand that in this particular regard, what has been the major judgments of the judiciary. So the first and the foremost important case that we have discussed before is in the year 2002, when the 11 bench judge of Supreme Court held a proceedings in the TMA Pai case, where it has clearly said that the scope of where the 11 judge bench of Supreme Court was given a task to look into the scope of right of minorities to establish and administer educational institutions of their choice under the constitutions. Following this, in the other case, this case actually was based on another case that was held in year 1971, that is called as DAV College versus State of Punjab. Here the question that was mooted with the court was that what constituted a religious or linguistic minority and how it is to be determined. Now in this important judgment, the court has ruled that the Arya Samajis, which is a kind of sect of Hinduism, though they were Hindus, they can be classified as religious minorities in the state of Punjab, even though they may not have been so in relation to the entire country. That means, while court has basically said in this particular judgment that even though the Arya Samajis may be, or the Hindu community may be a majority community on the national level, on the we can say nationwide level, but in the state of Punjab they are a minority, and that is why they can be classified as a religious minority. That means the further another case was there, that is called as DAV College Bhatinda versus the state of Punjab, and here court, taking the help of the previous judgment, has clearly said that Hindus were a majority in India. That is why they cannot be, that this whole ground, that since Hindus are majority group in India, they cannot be a religious minority in the state of Punjab. This is a wrong point, and that is why the court has rejected this particular stance. And basically it has said that for determination of whether it is a religious religious minority or linguistic minorities, the unit of determination can only be a state, not the nation. And that means a particular group, whether it is a religious group or it is a linguistic group, it can very well be the majority on the national scale, but it can be given the status of religious minority in any particular state if their numbers and their percentage share in population are lower. Further, this judgment has been solidified in another case that happened in the 2005, that is called as Bal Patil case, and taking help of the TMA Pai case, the Supreme Court has said that a state has to be regarded as unit for determining linguistic minority vis-a-vis Article 30. Article 30 we just have discussed before, that what does Article 30 says, and thus it has said that since religious minority being are on the same footing as a linguistic minority, it is the state in relation to which the majority or minority status will have to determine. What I am trying to say is, or what the court actually said, is that in the case of linguistic minority, if we are determining a state to be a unit, that means since religious minorities also have the same footing and all the similar to the linguistic minority, for their determination it also should be the state, should that be considered as a unit for the determination. So what we can say in conclusion, that the minority for the purpose of Article 30 cannot have different meaning depending upon who is legislating. That means it will not change whether it is central government is legislating or whether it is a state government or state we can say parliament is legislating at the central level, or whether it is a state legislative assembly is sitting at the state level, the minority definition cannot change. That means basically the position with regard to religious minority is similar, since both religious and linguistic minorities have been put on a par in Article 30. That means we cannot have two separate criteria to identify linguistic minority in a different way and identify religious minority in a separate way. Thus, conclusion can be simple that both religious and linguistic minority, as per as the Supreme Court ruling till now, can be classified and should be categorized on a level of a state, not on the level of nation. So that is about whole this issue. Today, the Supreme Court is going to hear the petition about declaration of Hindu as a minority in some states. So we'll have to look and try to understand that how and what the Supreme Court says. So that's all for now. We'll come again soon with depending on whatever Supreme Court's verdict is there. We'll try to explain that point also. So that's all for now. Take care. Thank you very much.